Welcome to this latest episode in this series produced by the Faculty of Party Wall Surveyors, where the theme, as you will see from the other episodes, is all to do with engagement, the engagement of the faculty in so many areas, such as engaging with members, potential members, the public, local authorities, different professions. And to continue with that theme, we're talking about engaging with the legal profession. And it gives me great pleasure to invite along today the faculty's legal advisor, Shaw Kelly, who's going to talk to us on a number of topics that I'll be asking him. So Shaw is the barrister at Boundary Wall Barristers. Fair to say you have a multidisciplinary practice, really, but that's your focus, isn't it, Shaw?
I do.
Yeah, but I'd like us to, obviously to focus here today on how, if you could provide a brief summary of your role with the faculty.
Thanks for inviting me, Stephen. Yeah. So my role with the faculty, I was invited earlier this year, of course, by yourselves to sit on the board and assist in perhaps a non-decision based role and advisory role. As I say, I don't make decisions at the meetings, the board meetings, but I hopefully give some insightful input into perhaps the legal aspects to the various points of discussion and topics that go on. So I do assist in that respect about twice a year in person and on the online meetings with yourselves. So it's more advisory than anything, and assisting with also training and education, which is the core purpose of the faculty, the ongoing efforts to assist and administer that throughout the faculty's membership. So I think those are the two primary roles that I have. And of course, assisting with interpretation of any case law. Now, the problem, I suppose, with that is you ask one lawyer about a case and their interpretation, or one surveyor even, you find perhaps another person or another lawyer or judge may not agree with them. So I think there's a vast interpretation out there, but hopefully we can give some legal advice and guidance on what the courts decide and where the act is going.
That's good, because that leads on to the next question I was going to ask you. You know, one of your key roles is to advise on the general membership of the faculty on case law, and it may seem an obvious question, but I'll ask it anyway. What are the benefits of surveyors having knowledge of case law, and how may they access this from the faculty?
Well, that's a very good question. Yeah. Well, the access point, I think that there's a case law database online that's accessible to surveyors and those with faculty membership, that enables them to see various cases that have gone on in the courts. And of course, we have higher courts. The Supreme Court is the highest court. The Court of Appeal is the next one down from that in the hierarchy, where we get some case law from. And one of the recent cases, one of the big ones, was of course Kyson and Power and Shah, which was the no notice, no act case. Going down from that, we have the High Court, and all of these deal with precedent, and they're binding on lower courts, the lower courts being the county courts and the TCC lists that we often deal with, whose decisions are often made by county court circuit judges, and they are not strictly binding on each other in terms of the case law that's presented before them, but very persuasive. And often the case law that we find quoted when we're dealing with cases is that at the county court level. So it's very persuasive, but it's not always binding, perhaps, whereas the High Court and the Court of Appeal cases are.
And it's we talked about the accessing these cases on the faculty's website. Would you advise surveyors to actually read the cases in their entirety? I say that conscious that there's some very good textbooks out there which give summaries. What would be your advice to us?
My advice would be to, if you can get through them, some great nighttime reading there in some of them, is to review the case law judgment in its entirety, if you have the time. Often there'll be a précis of the case, a summary presented. That's either by lawyers or perhaps surveyors themselves. But there's always a different take on that in some respects. You may take something from the judgment that I may not, or I might find something that you may not. So it's perhaps open to interpretation. Of course, there's what we call the ratio of the case, ratio decidendi, which is the main formative part of the case, which is binding upon the case decision. And then there's other things that are discussed that maybe, I think the Latin term is obiter dicta, words that are perhaps influential and persuasive. And so that always take the judgment first. There will be summaries. There's some good books out there. There's a green one and a red one. You'll obviously know that there's Bickford Smith and Nick Isaac Casey, his book as well. And I think Nick produces a case book as well that's quite useful with Matthew Hearson. That's due, I think, an update because, of course, I think it went up to about 2018, 2019. There's been some cases since then.
It's interesting what you say about the judge's comments made on the side. They're not leading to the rationale of his decision. And it's interesting when you said about, we can still take those into consideration, but be wary, I guess, with caution, is it? If it's not a point that a judge is making in the overall context of his decision, but nevertheless worth actually looking at what was said in that context.
Yeah, I think that's a fair point. Obviously, you'll have the main body of the decision that is important. Then you may have some other points. For example, I think one of your favourite cases, as I recall, when we spoke last at the course that we did, was Selby and Whitbread. I think that's about 5 or 6 points on the basis of the act, the interpretation, the easement aspect, jurisdiction of surveyors. So that's a very important decision. But squeezing those six points, you can bring those from the judgment. But if you're looking into a particular point, you may find that only 1 or 2 of the points are actually useful.
Would you recommend that surveyors make reference to certain court cases? I'm talking in the context of a primary award between 2 appointing surveyors. I know third surveyors will make often a specific reference to a case, but do you feel it's within the remit of surveyors producing that primary award at the early stages on a difficult aspect to make reference to a court case?
I think it can be useful, especially for a third surveyor when they're looking at perhaps the issues before them. And a third surveyor often will have more experience in respect of their party wall involvement and history and education. But I would steer slightly wide of that if I were a party wall surveyor, because you're straying into territory. There may be a point that's directly applicable, but you may be straying slightly off course, and if a lawyer picks it up, they may take a different interpretation. And if you're looking at the legal aspect, it may be legal points, but it can guide you. But I would say use it cautiously if you're going to quote case law.
There's no doubt that all these cases have helped us, given us guidance, haven't they? Often at the detriment of the losing party, but nevertheless they have guided us, haven't they? But it is the amount of case law that's increased significantly as from when I was a young surveyor working with the old Act. I remember we all had a copy of John Anstey's 4th edition of the Party Wall Act, and I think there would probably be half a dozen cases in there. But it seems like there's a case, or there was at one stage, there seemed to be a new case every month, it seems. And why do you think that is?
Since the 1996 Act, well, don't forget the London Building Amendments Act was strictly speaking London-based. So once the 1996 Act came in, opened it up to the whole country. So you may have decisions now from Birmingham, Leeds. I was in Leeds on Monday, and we had a case in the TCC list there that was listed but didn't go ahead for another reason. But there are various courts throughout the country that can deal with party wall appeals now, and I think that's an important feature, whereas before it was strictly London-based. And of course, the proliferation of building and construction that's gone on, not just within London over the last 30 years, but throughout the country. And I think that's important as well, because that, when you have a lot of perhaps extensions at the rear of houses, side extensions, often you may have to find a notice has to be served, a Section 6(5) notice, if you're dealing with extensions. And some people, well, most people are unaware of that. I find that some property developers outside of London unfortunately still unaware of the Act and its applicability. So that's another reason where the Act has been avoided, perhaps, and that's where we see cases, for example, where surveyors are brought in and the Act should have been applied but hasn't, so that forms a cause of action.
And do you feel that as construction techniques have changed as well since 1996, bearing in mind that the Act that we're working with at the moment was more or less cut and pasted from 1939, wasn't it? Together with some of the language that was used for that time, reference to servants and people like that. Do you feel that that has contributed to the amount of court cases? I'm thinking specifically about the amount of basements that are being constructed.
Yeah, of course. I mean, but basements, especially within London, where you have a terraced house or semi-detached house, and people can't really, or they've utilised the loft space already, and they think, well, we need some more space because we can't sort of move out. And I suppose with the prices of property in London, it's cheaper to dig down rather than buying a larger property, perhaps. So there are a proliferation of cases that are concerned with basements, and I can understand that completely. So yeah, it's generally the Section 6, the excavation work that we're concerned with these days, and perhaps that building along the line of junction as well, Section 1.
I think because this is a fascinating topic, and I'm going to ask you an all-embracing question towards the end, but what I'd like to ask you now is, many cases referred to by lawyers, and you've referred to one, the Selby versus Whitbread, but many cases referred to by lawyers, judges and surveyors predate the current Act. So how applicable are those cases, and are they persuasive?
They're very persuasive. They are, as you've mentioned, the 1939 Act, and there's no doubt the 1996 Act is very almost exact, in fact, to the provisions of the 1939 Act. Various changes in names and so forth, but and wording, but essentially we're dealing with an Act now that's 21 sections long under the new Act, the Party Wall, etc. Act, and you have to look at previous decisions. I mean, I still often use Lewis and Sadiq, which is a 1996 Act, just predating the Party Wall, etc. Act coming into force. But I still use that, and I still use other cases. Selby and Whitbread is one example. I think Leuston Kramer was another one. Going back in the years, Wall Street Properties, another good one that I like to rely upon. So that's there's a number of cases that are relevant to the current Act.
And the if and when an award is appealed, it's at county court level, isn't it? Which is not binding on itself or any other court. But many of the cases that are appealed do not seem to go much higher than that, to the High Court or the Court of Appeal. We hear about the famous ones. But if and when a case does go up the hierarchy, the chain that you eloquently described earlier, the High Court and Court of Appeal, do those judges in the High Courts look at the judge in question at county court level as to whether that judge is somebody that's pretty much involved on a regular basis on party wall matters? So in other words, what I'm getting to is the judge taken into consideration in the lower court as being pretty persuasive in himself or herself?
I think that's a very good question. Yeah, I mean, judges, I'm assuming, look at which judge is making the order which is appealed and the judgment itself. But I think the judgment takes priority as opposed to the actual who actually makes the decision. There will be some deference, of course, because a lot of the cases are dealt with at appellate level in the county court, as you mentioned, are in the TCC list, the Technology and Construction Court list. So that's an important feature because judges will be dealing with this on a regular basis. And we have, of course, in London, we used to have His Honour Judge Bailey dealing with the TCC list, and now we have His Honour Judge Parfitt, who is the main TCC list judge at Central London, sitting at Maresden City. So they will already have a wealth of knowledge in relation to party wall cases and party wall appeals that go before them, and be familiar with the cases and case law themselves. So yes, the courts will look at that, but also I think they'll take a closer look at the judgment and the grounds of appeal and the reasons given by the judge, as well as, of course, what the skeleton argument the particular lawyer sets out and argues on behalf of their client.
I think it's going back to the point you made earlier, is about context, isn't it? You know, whether it's a lawyer or a surveyor referring back to cases, you've got to be absolutely sure that that case you're referring to is applicable. You know, maybe some nuances which would disqualify it as something, but that is the difficulty, isn't it?
Yeah, it's being on point. Sometimes lawyers are known to stray. I may have strayed on occasion myself, but you often look at the case. You look at other cases that are similar if you're heading to appeal level. You look for precedents, of course. You might look for cases that actually are on point, but your case might distinguish that on the facts of your particular case. And there's always grey areas in which sort of cases are argued and where points perhaps have not been considered by previous decisions. And that's I think where lawyers tend to practice, especially at appellate court level, because what you're looking at is fresh facts coming into court that perhaps haven't been dealt with before by case law, but where cases are of a similar nature and you're looking to apply those principles to your particular case or distinguish them.
Yeah, it's an art, isn't it? It is an art in terms of interpretation and looking at applicability. This may be a very difficult question to answer, sure, but what do you think are the most, for you personally, I mean, we all have our views, but the most significant party wall cases pre and post-war?
Pre-96, I think that Gull Thompson against Wall Street Properties, which is dealing with the surveyor's jurisdiction, often in my context, I look at whether or not, I look at what the surveyors have done and whether they've ticked their boxes or got all their ducks in a row in terms of their jurisdiction, and selecting a third surveyor forthwith, which is what the Act says, but obviously, you know, there's some leeway in that in terms of realistically dealing with it forthwith, which means immediately. But so there's that particular case. I quoted Lewis and Sadiq, a 1996 case. Leuston Kramer, dealing with notices. That's ones I tend to look at as being important. Selby and Whitbread is another big one, but you'll find a wealth of cases going back to the 1800s, pre-1996. Post-1996, could I say Zizis and Lukomsky? I think that's an important one, how to deal with, because of course the Act and any award that's resulting from it, from the appointment of surveyors and the dispute, if there's an award produced, it has to be appealed within 14 days. However, what the Zizis decided was that you don't, if you believe or if you treat the award as being invalid, then you don't have to do anything at all, potentially. Or you can seek from the court a declaration on using a Part A claim outside of your 14-day time limit. So that often gives, I think, solace to appellants who have been told that they only have 14 days to appeal, when in fact, if it's an invalid award, you have a lot longer than that, because if you treat it as invalid, it is in fact invalid. So long as it is invalid, of course.
It's interesting that with Selby versus Whitbread, as you mentioned earlier, was multifaceted, wasn't it, in terms and great guidance to us. But a lot of those cases you mentioned pre and post 1996 are to do with jurisdiction of surveyors. And Daniel Ross in another podcast in this series was talking about the administration, the administration of the Act, and making sure your paperwork is correct, because everything else, if that's all wrong, the appointment, the surveyors, the correct service of notice, if that's all wrong at the very beginning, then everything else you do that follows from that renders the whole process invalid.
Yes. And
we're still at jurisdiction, aren't we? The importance of jurisdiction.
Indeed.
Where Judge Parfitt, who's currently sitting in London, the county court there, has had a few cases of this type in front of him, hasn't he?
He has. You mentioned about the administration points, and I think that's important because that founds, of course, jurisdiction. So, Wall Street and Gull Thompson and Wall Street Properties, of course, I think they went so far as to say, well, look at your opponents. I say opponents, your colleagues' letter of appointment, and ensure that that's correct. Ensure that they have been appointed. So that's an important feature. Post 1996, of course, His Honour Judge Parfitt has made decisions, and one of those decisions, one of the important ones, dealing with no notice, no act, is, I mentioned it earlier, Carson and Power and Shah, because of course that was dealt with, I think, encompassing a couple of my points now, that how it came about was by way of a Part 8 claim, a claim for declaration, because of course the surveyors in that case had not served, or the owners, building owners, had not served any notice at Shah. So that was a case where surveyors felt they had the jurisdiction to produce an award even without notice, and the first instance decision went before His Honour Judge Parfitt. He decided pretty much no notice, no act. Then it was appealed, and then it was appealed further to the Court of Appeal. In fact, I think there was an effort to go to the Supreme Court as well, but that failed. And of course, it leaves us with the famous decision of the Court of Appeal, in that where there is no notice, the Act doesn't have applicability, and any award will therefore be a nullity, void, and subject to rescinding.
That's a very good summary of where we are at the moment. It's been something that's been the subject of so many podcasts and forums, hasn't it, and articles as well. And we mentioned again in another episode to this series about the importance of getting the notice correct. I mean, that's one thing in terms of jurisdiction. The notice sets everything in motion, doesn't it? But it's what the service of a valid notice brings with it in terms of the building owner's rights, isn't it? And avoiding the possibility of a claim of trespass and nuisance at common law. That famous phrase that was mentioned by Judge McCarty in Selby versus Whitbread, that the service of a notice supplants common law rights, which is an incredible piece of legislation when you think about it, isn't it?
That's right.
And very hard for lay people, or even surveyors and some lawyers probably, to comprehend what the service of a notice can be, what it represents, that supplanting of common law rights. And that's why the importance of having the notice correctly served, that the surveyors are correctly appointed, is so vital, isn't it?
It is a powerful piece of legislation when you think about it, having the right to interfere with a party wall which is half owned by your neighbour. I think that's the first point, and the second point is building upon the line of junction, or against the line of junction, if your neighbour objects, and of course the excavations going below those of your neighbour's land, and potentially these issues do cause friction amongst neighbours, and it's a perfectly sensible piece of legislation when you think about it. Get two surveyors together, or one agreed surveyor, and sort this dispute out. the Act perhaps could do a bit of improvement when it comes to defining what a dispute might encompass, but because of course it shouldn't be something frivolous or something so minuscule that it doesn't necessitate the involvement of surveyors, but it should be a real and valid dispute in order for the process to take effect.
And that's where surveyors really do come into their own, isn't it? They're trying to get the balance right, isn't it, between a building owner, the person that's doing the work, establishing their rights to do certain works, but the obligations they owe to the neighbour.
Correct.
To undertake those works in a way which will mitigate the risk of damage and unnecessary inconvenience. And that's the difficulty side. And obviously gaining access to a neighbour's site to undertake certain works is inconvenient, and the law recognises that building works by its very nature is inconvenient, isn't it? It's where the surveyors earn their crust, is establishing what is unnecessary inconvenience.
Yes.
And that is something that is open to opinion again, isn't it?
Open to opinion and interpretation, of course, because what might be inconvenient for one person might not be inconvenient for another. And it's down to the sensible resolution of the dispute by the two, often the two, sometimes three surveyors in question. And so long as the surveyors exercise that duty that they have been given with care and skill, I think the law and lawyers should not be involved. But where they perhaps depart from that sensibility and go off on perhaps a frolic, if I could put it that way, that's when the appellate system is in place. And it's important, of course, because one party or even both might have a right to use that and exercise it.
I haven't put you on the spot about favourite court cases pre and post 1996. I'll share with you my, pre you've already probably guessed, haven't you? It's Selby versus Whitbread. But post for me, one of the most useful ones was Chatterjee versus Fairholme in the context of special foundations. And special foundations, it's defined in the Act as an assemblage of beams and rods. And clearly, we were talking earlier about the terminology, this archaic terminology used from the 1939 Amendment Act, which was brought in to deal with these steel beams that are laid across at right angles to one another, forming foundations, which created difficulty when they were actually placed on neighbouring land, where the building was placed up against it. But for some reason that's never been explained to me, we as surveyors have also adopted that definition of a special foundation to talk about reinforced concrete foundations being placed on neighbouring land and the difficulties that may cause. And then the Chatterjee versus Fairholme case, which Edward Bailey, the retired judge, made a decision on, managed to put forward, listening to conflicting opinions from the respective engineers about what was a foundation, special foundation. And in this particular case, it was a reinforced concrete wall of a basement, wasn't it? Was that wall part of the foundation or not? Well, out of that case came the famous phrase, the Bailey rail, this concrete named after the judge, this bit of mass concrete that had no reinforcement on it at all, and it was considered that was a sham, placing this bit of unreinforced concrete, the Bailey rail, underneath the reinforced concrete wall at its junction with the reinforced concrete floor in this basement. And so people are still split on their views of that. Was it a sham or not? And the engineer, I think, managed to convince everyone that's the way he always designed it, that the reinforced concrete foundation, the mass concrete foundation was used for other reasons as well, for the secondary, the temporary supports as well. And it got through. But I think what I'm getting to in a roundabout way is we talked about this old language used in the Act, and that's an example where I feel personally that if the Act is ever revised, we should remove that provision of special foundations, because it creates so many difficulties where somebody's proposed design, particularly for a basement conversion, completely be scuppered if the adjoining owner does not consent to the placement of special foundations on their land. And I feel it's useful that way. It seems to put to bed for a while until it re-emerges again, because we are conscious that Chatterton versus Fairholme was case specific, but it does put to bed for a while, that issue. But is there any parts of the Act that you feel, if you had the opportunity tomorrow, so there we are, Shaw, we've given you the job to revise the Act, is there anything specific you feel that should be amended, omitted or added?
I think that's a very good point, actually, the special foundations one, because building design and techniques and technology change. So why not have amendments of wording at times, perhaps not only in relation to special foundations, but also perhaps of design, because of course, buildings change, don't they? We'd never have cavity walls if everything was sort of a double-skin brickwork. But I think that's an important feature, and perhaps something left best to surveyors to deal with. Personal bugbear of mine is perhaps the lack of definition when it comes to a surveyor under Section 20, because I think so open to interpretation now that anyone could be named as a building owner or an adjoining owner's surveyor, and under which case they're then charged with a duty to deal with issues under the Act and have a statutory duty, which seems bizarre when you think about it, because to the average layperson in the streets, you'd think that a surveyor would be someone with a qualification, qualified to deal with building design and building pathology, the execution of works and so forth, have some knowledge of basic structural engineering foundations, but the Act doesn't define it. And I think that's a little bit bugbear of mine, but it's something that I feel would need an amendment to it, because of course it's an important facet of practice, if anything, because you instruct a party wall surveyor and you expect them to be qualified in some way. So I think that would be an amendment of mine.
Yeah, it's a peculiar thing, that definition of a surveyor, because it actually it doesn't tell you what a surveyor is, but it tells you what a surveyor cannot be. And it says he cannot be, or she cannot be, a party to the matter.
Yes.
So as long as they're not the building owner or the adjoining owner, as you say, it can be a surveyor. But I do remember doing some research on this and looking at the Hansard debates, and they had set time aside to actually define who a surveyor is. But they, as you mentioned at the beginning, it had to be rushed through fairly quickly, this piece of legislation, and they clearly didn't get round to it. Not a criticism, but they really were under the cosh in terms of trying to get this legislation through.
You've done more reading than I have in regards to the readings and the various stages of the bill as it then was introduced by Will Lytton. But it's an important missing feature, I think, that deserves perhaps addressing. And I think there's mention of, you see in some of the cases, I think in one or two of the cases with His Honour Judge Bailey, now retired, where relatives had been the surveyor of choice, and unqualified in some respects.
And impartial, not impartial.
Not impartial. But, so the Act says the Act in reality is that you should have a duty to the Act and above everything else, but with one eye, of course, on your appointing owner, but your overall duty is to the purpose of the Act.
You get involved in appealing party wall cases, and they can be very expensive, can't they? An expensive process, and I'm conscious now that there's a tendency for parties to seek mediation as an alternative dispute resolution process to the expensive civil litigation route. How do you see mediation becoming a significant alternative dispute resolution process in the party wall context in the future?
Very important, because of course you have naturally a neighbour type dispute before you. And when it gets to lawyer stage, and I think what the courts have recognised, and I've seen often now in orders, breaks in the litigation, because of course you have 14 days to appeal an award, and then you're in the system, you're in the process of litigation. So it's very sensible to have an early breaker, I think, at that stage for potential mediation to occur, especially where a decision or an award is so wrong that it warrants review. So mediation is an important dispute resolution process, I think, that's of benefit in cases such as these. And in fact, there's, I think it was, I can't remember, it was earlier this year or last year, the case of Merthyr Tydfil, I think it's called Churchill Merthyr Tydfil, says that in some instances, courts can now impose upon parties an order for mediation to take place, as opposed to in previous times when it was purely voluntary. Obviously, there's cost implications of those voluntary refusals. But in terms of it being used as a alternative dispute resolution procedure, I think it's very useful, and parties should be encouraged to use this.
I found it very useful. I've sat in as an expert witness on probably about a dozen cases now that, admittedly, not all party wall. In fact, none of them were party wall. They were to do with this, building defects. And I find the process quite interesting in that the mediator will move between the rooms of the parties, trying to cajole the parties in reaching a decision, and we'll see if there's any common ground. It's a totally different approach, isn't it, to my experience appearing in court as an expert witness.
It is. It's more collaborative and often more collegiate between the lawyers and the parties involved, because what you're trying to get is a result that's of benefit to both sides, and it's something that often the legal procedures and litigation cannot provide, because often there's just one winner and one loser in a court case, whereas mediation gives you a lot more breadth in terms of how you can proceed with the case and what you can do with it, and if there are any residual issues between the parties, perhaps they can be included in the mediation process and have that agreed as a perhaps a collateral issue or satellite issue that may something you can't do in litigation, but you can actually deal with it in mediation. And taking that approach, I think that once you get the parties together, it often provides a route that's I think more beneficial, because often the building owner and adjoining owner will have to be neighbours for many years after that. So that's important as well. And the court process, as I say, doesn't necessarily give you that, because you'll often have one winner, one loser. And unfortunately, the loser will often have to pay a lot of costs, not only their own costs, but the costs of the other side as well. So that's an important feature, and that's avoided potentially through a mediated settlement.
So in the right circumstances, the advice would be if an award has been appealed within 14 days, you can make that appeal, but subject to, or a stay in appeal procedures subject to mediation. That would be a way forward.
That's an option. I think, as I say, that can be sometimes fought through by the court itself, and sometimes the order is made suggesting or strongly suggesting, or it can be part of an order, or it can be purely on a voluntary basis through an offer from the lawyers. And I think that's important. There's not only mediation, of course, but negotiations that can occur. And unless a decision, an award is so wrong, in which case it's either quite binary and it's either right or it's wrong. If it's so wrong, then it may be that the mediation process is redundant, because it may be argued that it's futile, because if an award is so wrong on its foundations that it should be set aside, then there's no point in undertaking mediation, arguably.
Very good. Well, with a couple of minutes to go, Shaw, I'll ask you another difficult question, but it probably ain't warrant, and I'll forgive you for doing so, a short answer. But do you have any views as to how the law and the Party Wall Act will evolve over the next 10 years?
You mentioned about a short answer. You should never ask a lawyer for a short answer or a brief answer. How might it develop? I think we could see amendments. I think the engagement with the training of surveyors is important, and looking at that in a long-term way, and having proper party wall qualifications. Party wall for surveyors is maybe an important way forward. That may be one route for the Act, and I also think that perhaps technology coming in. We mentioned that the faculty has the online case law database. I think looking at how technology is advancing, perhaps there may be a room or scope for a platform for assisting surveyors with resolving disputes and perhaps notices and ensuring that your notice is right and having that overlooked perhaps by the faculty itself. And I think that's one way that we might be heading. So pretty much technology and education are the most important points, I would say. And of course, mediation, as we've discussed, that may be another route or influence that the Act might consider in any potential amendments.
Well, education you've mentioned, and engagement you've mentioned, with the law, with the parties, with the courts, all recurring themes that have featured throughout this podcast series that we've done. But introducing technology to a Luddite like me, I welcome that as well. And maybe there's a chance to be yet. But thank you. I imposed upon you quite a brief, didn't I? It's the reverse all of the roles here, isn't it? But I think you've covered it and you've answered it in the time allotted very, very well and very, very eloquently. I thank you for your time today, Shaw, and I hope the viewers and listeners on this podcast have found it particularly interesting and giving some direction and some comfort as well, and some thoughts for the future. Thank you for watching and listening.
And thank you for inviting me, Stephen. Thank you.